Ozzy Osbourne had that public procession you were talking about, but he also had a private funeral where he was buried on his estate. And that kind of echoes what he had said publicly, because he said he didn't want to be cremated, he wanted to be buried, and he wanted his funeral to be a celebration of his life as opposed to, as he said, a moat fest. All of us can actually take control and plan for that by some of the laws that we have in Michigan. A few quick tips. The first is, if you do the document and you have any specific wishes about your funeral or burial or services, don't just designate someone. Actually put specific wishes and what you want in the document. The second tip is, when you do the document, make sure your representative has a copy of it or knows where it's located. If not, it doesn't do anyone any good. And lastly, you always want to have an alternate on the document just in case something happens to the initial person that you designate. At this point in time, no will has been filed, and that's really not surprising, because with his estate, which is tens of millions of dollars, it's most likely he did a trust or many trusts. But what's really interesting in his estate, at least for me, is that reportedly his daughter Brooke said that she wanted to be removed from his will and trust a few years ago because she didn't want to deal with any family drama or tension down the road. It's very unusual. You know, I've been doing this almost 3 decades, and for a child to say they wanted to be removed is definitely atypical. Yeah. But what's not atypical is fighting over wills and trusts. And I actually give her a lot of kudos for thinking ahead about that family drama, because that drama is expensive and time-consuming. And in this case, with the third marriage situation, it's very typical. He has a $32 million estate, as you said, but he didn't have a will. So at this point, under the laws in the UK, everything's going to his 8-year-old son, which is a lot of money, and the people controlling his estate, because he didn't have anything in writing, the court appointed his ex-girlfriend and an attorney in the music industry. The biggest issue is we don't really know what they want. I mean, did Liam Payne want his son to receive all of his money? Did he want to leave some to his current girlfriend or parents or siblings? When someone doesn't put their wishes in writing, in the U.S., just like what's similar to happening in the UK, is the state you live in decides who receives your money and how, and when you pass away without a will and you're not married, everything goes to your child or children. I encourage people to work with an attorney, which he initially did. He did a will saying he wanted to be cremated. But then a few years later, in his hospital room, he signed a handwritten note with 2 of his kids saying he wanted to be cryogenically frozen. We don't know if this is what he really wanted. There was no attorney there. And he had another child, his daughter, who tried to fight this. She said that was not what her dad wanted. Eventually, she ran out of money. And so as we speak, Ted Williams is suspended in liquid nitrogen.
Wow. Okay, moving on to Babe Ruth.
He did a great job with his estate planning. Back in 1927, he actually did a trust to provide for his 2 daughters and his wife, which makes it so much easier. It's private, you avoid the court, and it's easier to administer. This is such an important topic. The first misconception is that hospice means you're giving up. That is absolutely not the case. Hospice is about enhancing quality of life, giving you more care and support, and really it allows you to have a team of healthcare professionals to support you and your family. So many times I find with clients who have been on hospice through the years, they say, I wish I would have done this sooner because it's so wonderful to have the additional support. And that goes to another misconception which we have, which is if you go on hospice, you're going to pass away soon. That is not necessarily the case. I've had clients on hospice for years sometimes. In fact, Jimmy Carter was on hospice for almost 2 years before he passed away. It's actually very surprising because a lot of us don't think of it as a woman's disease, but 2/3 of Americans who have Alzheimer's are actually women. And once we turn the age of 60, we're twice as likely to get Alzheimer's as we are breast cancer. And in addition to that, the largest demographic of people caring for those with Alzheimer's is also women. So many people don't realize this, but when you're going between 2 states, you actually need to think about home, car, and health insurance. Ooh. So, for instance, if you're down south for the winter and something happens to your home up here in Michigan, it might be an issue depending on your coverage because they could consider your home vacant or unoccupied, and you may not have the coverage you think you need. Residency is a big issue. A lot lot of people want to become residents of a particular state because of income taxes, estate taxes, and sometimes even who you can leave your money to when you pass away can be affected. So if you decide you want to be a resident down south, let's say, or Michigan, you really need to dot your I's and cross your T's, because if you don't do it properly, you could get audited, and that could lead to all sorts of issues. Prior to this, people had to leave the state of Michigan if they wanted to use a surrogate. So now they can actually go through the process in Michigan. There's a variety of safeguards in place right now. Everything from the surrogate having to go through a medical and mental health evaluation to the parents actually having to go through a mental health evaluation. And then both of the parties need to be represented by their own attorney, which makes a lot of sense because these contracts are very, very complicated between the parents and the surrogate. It happens all the time. Sometimes there's just not enough money in an estate or a trust, and the creditors don't get paid. We had a case in our office where there was a hospital bill for $1 million. There wasn't that much money in a particular estate, so they didn't get any money at all. Other times we're involved in our office in reducing creditor claims because there might be a variety of creditors that come forward. They might say they're entitled to X, but we want to try and reduce it to Y. So that's something your attorney can help you with, getting those creditor claims down to make sure there's money for the beneficiaries, but also to make sure, to the extent you can, you do pay off those creditors. There's a lot of different warning signs. Probably the biggest one is secrecy. So if the person in charge isn't sharing information and isn't being transparent with what's going on, that is a huge red flag. A couple other warning signs is they're not following the terms of the will or trust, or maybe they're doing things in their own self-interest that benefit them and not the beneficiaries. We get calls all the time to our law firm with people saying, I'm suspicious of what's going on, and sometimes the suspicions are unfounded, but a lot of times they're not. One of my partners just won a $2 million verdict because someone reached out thinking that there was something fishy going on with the trustee. And these things can range from crazy things like giving money to beneficiaries for cosmetic procedures like Botox and filler, to missing millions of dollars in assets. So it really runs the gamut. We need people to trust us as attorneys because the goal is for the client to be able to share whatever they need to. And a lot of times, as you can imagine, it's personal information, it's tough to share sometimes really sensitive or complicated, and they need to have that trust between themselves and the attorney to feel comfortable. So knowing the attorney can't share that with anyone else, which is essentially what attorney-client privilege does, makes people feel a lot more comfortable. Kind of like going to the doctor, how you need to share everything with the doctor. What's interesting is when you bring someone else into a meeting with the attorney-client privilege isn't there anymore. Because now instead of just you and the attorney, there's a third party involved. And this is not just meetings with your attorney, but this is even emails with your attorney. So if you're emailing your attorney and including a friend or family member on the email, you may want to think twice about that.